It's case number 2025 CR 19. Chris Ambrose appears as defense counsel. The defendant, Mr. Korn, appears from the Greenwood County Jail Zoom location. Jill Gillette appears as Greenwood County Attorney for the state of Kansas. This matter comes before the court at this time for sentencing. The pre-sentence report would indicate that this defendant had appeared before the court on June 5, 2025. At that time, pled no contest to an amended count 1, unlawful distribution of a controlled substance, methamphetamine, a level 4 drug felony. And all the other counts were dismissed. I do note, however, Mr. Bauer, that you list an additional offense in count 6. Was more than one charge pled to back on June 5?
I believe that he pled to both of those, Your Honor.
I do see that from the case notes.
That was a mistake on my.
All right. Count 6, interference with law enforcement, a level 9 non-person felony. It was also a crime of conviction. Pre-sentence report was ordered and sentencing set for today. Court has received, obviously, the pre-sentence investigation report compiled by Tony Bauer, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history, which is stated in the report?
No objection to the criminal history, Your Honor.
Any objection by the defense, Mr. Ambrose?
No, Your Honor.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score B, and the court will proceed further accordingly. Mr. Ambrose, do you know of any legal reason why sentence should not be pronounced in this case at this time?
No, Your Honor.
Ms. Gillette, are you aware of any such legal reason?
No, Your Honor.
Mr. Korn, are you aware of a legal reason or any other good reason why we shouldn't proceed further?
No, sir.
We'll proceed further with sentencing proceedings then. I'm not aware that there's been a motion for a departure or any other sentencing related motion to take up. Mr. Ambrose, do we have any motions to pursue?
No, Your Honor.
Any motions from the state, Ms. Gillette?
No, Your Honor.
All right. Are there any victims or members of a victim's family present who desires to address the court in relation to this sentencing? Court finds no such persons present, so the court at this time will ask for recommendations from counsel regarding an appropriate sentence for Mr. Korn. We'll begin with Jill Gillette on behalf of the state.
Your Honor, we have made an agreement in this case for Mr. Korn. He already has a KDOC hold on him. We're all aware of that. We had his prior PSI from Independence. And so he was on parole when this case happened. Part of the agreement, he took this plea early on in his case, moving through things. The state is going to recommend the mitigated number of 41 months, so that we're aware that he's going to probably have his other case be consecutive to this one. So I'm going to recommend the mitigated number of 41 months. We took it into consideration as he was originally charged with a 2, that we knew he was going to be going to KDOC. With that mitigated number, his post-release supervision would be 24 months. There's not a departure to that we're seeking here. He has a 20% good time credit. He has been transferred over here, but he's still on a KDOC hold. I don't know how to really treat the time that he's sitting here with the KDOC hold on him. With all the special rules that have been coming out, I think it's appropriate to write down the days he's been in our jail. And I don't know if KDOC sorts that out or if we sort that out. On count 6, his sentence would be 5, 6, or 7 months. The state's going to recommend 6 months. No objection to being concurrent with count 1. It does still have the 24 months post-release supervision and up to 20% good time credit. Mr. Korn is going to be heading off most likely here to KDOC. There is a $400 KBI lab court cost. His DNA is already on file. And there is a booking fingerprint fee of $45. We had asked the court to inquire pursuant to Robinson of his bids application and attorney's fees. This was a special rule case as it was committed while he was on parole, conditional release, incarcerated, probation, or post-release. He has several different cases. There is a Wilson County case for which he was on parole, 16 CR 53. It is a felony case. There's a parole case, Montgomery County, 16 CR 124. And he had case from Montgomery County, 18 CR 280. It is also a felony case. This case should be by special rule consecutive to those cases. It's one of the reasons we've taken into consideration the number of months and reducing the number of months that he would serve on this matter. And taking into consideration recommending the mitigated number of 41.
Very well, Ms. Gillette. Mr. Ambrose, your recommendations regarding an appropriate sentence?
Yes, Your Honor. We'd be joining the state's recommendation asking for a 41-month underlying sentence on count 1, an appropriate sentence on count 6. We'd join the state's request that those be served concurrent to one another. I believe the state was correct about post-release supervision links and that kind of thing. I want to note a couple things in particular as we finish this up. The first being the jail time credit issue. My reading of State v. Irvin, which is I think, most recent Kansas Supreme Court case on the jail time credit issue when someone's in custody and has holds elsewhere, which came down on, the opinion was filed on April 11th and 25. In State v. Irvin, they indicate that KSA 216615, which governs jail time calculations, allows a jail time credit for all time a defendant is incarcerated pending disposition of the defendant's case. A sentencing judge should thus allow credit for all days incarcerated on the case, regardless of whether the defendant received credit for some or all of that against a sentence in another case. That is syllabus paragraph 12 of that Irvin case. We've just started seeing this show up in cases. This getting argued in the last month. Feels like it's still pretty new, like Ms. Gillette kind of indicated. I think according to that case, it's appropriate that jail credit for the time that Mr. Korn has been in custody, which would be since February 23rd of 25, be counted towards as credit for jail credit pending sentencing in this case. Moving on, the next issue that I'd like to speak about would be Robinson factors.
Let me stop you there.
Yes,
Hasn't there been a legislative statutory fix for offenses after May 2024 that would make the Irvin case inapplicable?
I can have the answer for that in just a
Do
second.
I see a nod from Mr. Bauer?
Your Honor, I was just messaging Chief CSO Sarah Wheeler to ask her about that. I know there was something that came out in May that corrected that and said consecutive sentences. They do not get jail time credit in multiple cases if there's consecutive sentence order. I don't remember. I was trying to find what it was. I was messaging Chief CSO Sarah Wheeler to find out if she knew what that was, but it was a legislative fix that corrected that.
My understanding that may have been a 2024 fix.
I believe so.
And I just do note that Mr. Korn's case originated in 2025. So I think that he'd be subject to the new statutory section. Ms. Gillette, can you shed any light on this?
Judge, there's been so much change. My thought is that we award the 165 days. And if KDOC decides to calculate it differently, then there can always be further appeals. That's what I've been doing on all of my cases, is I've been awarding the time and then letting basically KDOC's sentencing computation unit sort it out. There was the legislative fix. I'm not always 100% thrilled with language in certain statutes. There's lots of them, including the DUI statute, that I'm like still baffled by.
Well,
But
Ms. Gillette, do you have access to the most recent version of the Kansas County and District Attorneys Association magazine? Because I think there's an article in there about this.
not on my desk.
All right.
In your honor, for full, just to have full candor with the court, I'm looking at the statute here. I'm looking at the 2024 version, which would be when a legislative fix occurred, and Mr. Korn's, and it shows that became law July 1st of 24. Mr. Korn this case started after July 21st, 2024. KSA 216615A talks about the basics of how we govern this credit when someone's in confinement. But KSA A1, but A2 states the following. A2 states, when computing the defendant's sentence, the following shall not be considered time spent incarcerated pending disposition of the defendant's case. A, any time awarded as credit in another case when consecutive sentences are imposed on a defendant, which is likely the issue here, is that if the court was to order consecutive sentencing here, which I think the court has to by matter of law, that anytime credit awarded in another case when consecutive sentences are awarded shall not be considered time spent incarcerated pending disposition of his case. So if that time, and from that, I'll go back to the PSI and the language that Mr. Bauer used in that. The language that Mr. Bauer used in the PSI on, one second here, credit for time served, page 4, in the bottom of that official version section, it states the following, that Mr. Korn was booked into the Greenwood County Jail on February 23rd, 2025, and has remained in the jail since. However, Mr. Korn has had a parole hold on him the whole time, so all credit should go to the parole hold. And so I wanted to be clear with that, that's where we're at, and I believe where the law stands. As a matter of course, I'm going to ask the court to make sure, just for preservation purposes, that the court to consider granting the credit for time served for Mr. Korn. However, that is kind of the lay of the land based on what I can see there. I just want to make sure we have full candor with the court.
Well, both you and the prosecuting attorney have suggested that the court not follow the law. Go ahead and give him credit when the court knows that he's not entitled to it. I mean, I understand your attempts to be magnanimous. I'm not going to let DOC sort this out. This is a decision for this court to make. I do appreciate you actually referring to the 2024 version of the statute to essentially verify what the court already knew, that essentially the rules have changed.
Thank you.
But I thank you for that, counsel. You were moving on, I think, to something about the bid assessments.
The Robinson factors, yes, Your Honor. Just so the court's aware of what's going on with that. As of right now, I anticipate that my bill to bids on this case is going to be around $1,100. Just so the court's aware. We'll note that we anticipate, based upon the agreement of the parties and how the PSI came back and the fact that we don't have any, departure motions or anything, Mr. Korn's going to be going to custody, going to DOC on this case for at least 41 months at the bare minimum. Beyond that, I have spoken with him. It's my understanding that he's going to have, he does have these parole holds, and he's got about 3 years of parole time on top of his head. That in addition to this case, he could be serving up to 3 more years on parole in this case. He lacks the financial means at this time to be able to make any meaningful payments in this case. And upon completion of a sentence in this case, he's going to have to get out and begin to restore his life. But he's not an individual that has outside resources available. So we would ask the court to consider waiving or abating bids application and attorney's fees in this case.
All right. Anything else, Mr. Ambrose?
I don't believe so, Your Honor. Thank you.
This time, the court will address the defendant, Mr. Korn, personally and ask him if he has any statements he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Korn?
I just want to apologize to the court and the community for my role I played in this. Take full responsibility for my actions.
Very well, thank you. The court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of B, thus placing him in grid box 4, drug B. The court hereby sentences the defendant to.
It's possession for distribution. It's a severity level 4. I think you said 5, but it's a 4.
Thought I said 4. Okay.
Said 5.
It is a level 4 felony. Court will announce a sentence of 41 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 24 months of post-release supervision. No fine is imposed on that count. On the additional offense of interference with law enforcement, severity level 9, non-drug, non-person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 9I. The court hereby sentences the defendant to a term of 6 months in the custody of the Secretary of Corrections. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to the same 24 months of post-release supervision, noting that the methamphetamine charge would be controlling on that issue. No fine is imposed on that count. Court does run the count 6 concurrently with the time imposed on count 1. Controlling sentence, therefore, is 41 months in Department of Corrections custody. This sentence shall be run consecutively to Montgomery County cases 18 CR 280 and 16 CR 124 and Wilson County case 16 CR 53. Regarding the issue of jail time credit, Mr. Korn, I think this court is forced to rule that because these are consecutive cases, you're not going to get jail time credit for the time that you've served in the Greenwood County Jail waiting to be sentenced in this case. However, I assure you, I don't like the concept of dead time. I am confident that you will get credit for the time that you've served in one of your other cases. If you don't, certainly with proper application to this court, you'll get it here. Because you've done the time, you need to get credit for it somewhere. I think DOC will, of course, credit it appropriately to one of those other cases.
All right.
Court will be assessing $400 restitution to the KBI laboratory. Felony docket fee is assessed to the defendant, and a $45 booking and fingerprinting fee. All business assessments are waived due to the court's incarceration order. It's not workable to have him pay those amounts. At some point in the future, Mr. Korn, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address that to a lawyer and I'm sure get your question answered. Under certain circumstances, a criminal defendant may have the right to appeal their conviction to an appellate court having jurisdiction, and if they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days for this judgment in court to file any notice of appeal with the clerk of the District Court of Greenwood County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I do believe, Mr. Korn, that this is a registration offense.
Your Honor, registration offense, and we have already done the duty to register. It was signed by Your Honor and filed with the court.
All right. I will just remind you of your obligations to register as offender at all times that you're not incarcerated, Mr. Korn. There are also prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. I'll remand the custody of Dustin Korn to the representatives of the Greenwood County Sheriff's Department until his custody can be appropriately transferred to the Secretary of Corrections facilities. The court will just state for the record that obviously in criminal history category 4 drug B, he was presumptive prison in this case. The court has followed that statutory presumption in imposing an incarceration sentence in this case. That stated, Ms. Gillette, is there anything further that the court needs to address here?
No, Your Honor, thank you.
Anything further from your perspective, Mr. Ambrose?
Not for today, Your Honor. Thank you.
Mr. Corn, I would just encourage you to try to earn every good time credit day that you can while in Department of Corrections custody to try to earn your earliest possible release date.
Yes, sir. Hey, and I had one question. Me and Ambrose talked about me trying to get my phone back. That was I didn't know if he was going to file a motion today or.
Yeah, I'll work with Ms. Gillette on that. We'll probably just submit an order to get that taken care of.
Okay.
All right.
All right.
Ms. Gillette, you see a problem there?
No, once cases are done, we usually release those, but we usually put it in their property and or if they have a family member to pick them up. So it's whichever way it needs to go.
Yeah, I don't think KDOC is going to let you have that.
No, I know. I have somebody that can come pick it up though.
All right. Very well.
All right.
We'll let counsel work on that issue and appropriately submit an order in that regard.
All right.
If there's nothing further then, this
No.
matter will currently be in recess and this meeting may be ended for all at this time.